Hear ye, hear ye. The first district court of appeals is now open. All who have business before this court draw near, give attention, and you shall be heard. God save the United States, the great state of Florida, and this honorable court.
Please be seated. We begin this morning with the HCA Health Services of Florida and others against the Agency for Healthcare Administration and another.
Good morning. My name is Stephen Menton with the law firm of Rutledge, Assenia, and Purnell on behalf of the appellants, St. Lucie Medical Center and Longwood Medical Center. I would request to reserve 2 minutes for rebuttal.
All right. Keep an eye on the clock. The light will go on.
Thank you, Your Honor. This is an appeal from a final order entered by the Agency for Healthcare Administration approving a certificate of need, or a CON, for Martin Memorial to build a new 80-bed acute care hospital in West St. Lucie County. My clients, Longwood Regional Medical Center and St. Lucie Medical Center, are existing hospitals that serve the market where the proposed new satellite hospital for Martin Memorial would be built. As discussed in our briefs, this was the 7th CON application filed by Martin Memorial in a 5-year period seeking approval for a new hospital in the same general area in West St. Lucie County. All 6 prior applications were denied by final orders entered by the agency. The 7th application was filed only a few weeks after the agency preliminarily denied the 6th application that Martin submitted. The statutes governing the Certificate of Need process in Florida is the Health Facilities and Service Development Act, which begins at Section 408.032 Florida statutes. The CON law requires hospitals to obtain a Certificate of Need prior to implementing certain new health care services or projects, including the construction of a new hospital. Over the last several years, there have been several projects that have been...
You don't need a CON just to add beds, right?
Yes, sir, that's correct.
And that's one of your points, right, that St. Lucie is in the process of or will soon add 35 beds.
That's exactly correct, Your Honor. I think one of our points on appeal is that the addition of those 35 beds was not considered or discussed in the recommended order issued by the administrative law judge, and that is a significant change in the market that exists since the time of the denial of the 6th application.
All right, so you would say, looked at from that perspective, there are differences in the circumstances between what existed at the time of the 7th batch and what existed at the time of the 6th batch.
I think it's inevitable. There are always going to be some changes that are going to occur with the passage of time. The question is, do those changes justify a different result than what was reached in the final order?
But isn't that question uniquely a kind of question that should be answered by the person who hears the evidence and the facts?
Well, Your Honor, I think that certainly...
I mean, you're talking about something, if I understand you correctly, you're talking about something that is akin to like the weight of the evidence question, not whether there was a change, but whether it was substantial enough to justify a change in position.
Your Honor, I think actually in this case, one of our main points is that the judge, the administrative law judge in this case, did not, in her recommended order, take into consideration the changes that supported the prior denial of the request to build a hospital in West St. Lucie County. In fact, only identified a couple of minor changes that supported a different conclusion without weighing those in the context of the changes that supported the original conclusion. And in that regard, I think there were some very significant differences from the time of the denial of the 6th application, one being the one that Judge Benton just mentioned, which was the addition of 35 beds at St. Lucie Medical Center at a cost of $23 million. In addition to that, one of the major factors cited both in the 6th application that was submitted by Martin Memorial and in the 7th application was the purported need to increase access to emergency services in the West St. Lucie County area. From the time of the denial of the 6th application, that argument was found to be not persuasive in denying the 6th application. From the time of the 6th application and after the 7th application was filed, Martin Memorial went out and began to build an off-site emergency department right in the area where this proposed hospital would be built to the tune of $6 million. that was not even discussed in the 7th application, and it is a change in circumstance which directly addresses the need that Martin Memorial had attempted to address through its application. The judge, the administrative law judge in this case, mentioned that in her recommended order, but simply said it was a, quote, interim measure. I would suggest to you that that is not consistent with what the goal and purpose of the Certificate of Need law is, which is to review the need for a new facility and to avoid the duplication and unnecessary expenditure of healthcare resources. Here you've got a situation where, to the extent there was any need, which was found not to be enough in the 6th application, that need is being addressed both through the addition of 35 additional beds at St. Lucie Medical Center and the construction of the off-site emergency department. The total of those is almost $30 million in healthcare expenditures to address the healthcare needs in that area, and that has not been fully and properly evaluated in the recommended order issued by the administrative law judge or in the final order by the agency. The agency simply said, well, the judge has finding of fact authority and we can't revisit those issues. But we're talking about $30 million that was spent since the denial of the 6th application that directly addresses these needs, and that balancing of the impact of how that addresses the need in that area hasn't been fully taken into account. Now,
but I mean, it was an interim measure, right? Isn't the plan to build a new hospital that would include an emergency room, and at that time to shut down this freestanding emergency room?
well, Your Honor, the testimony, I believe, was that they would convert it to an acute, into an ambulatory surgical center or something similar to that, so it would continue to serve. I think my point, though, is that as long as we have a certificate of need law, as long as we have a law that is supposed to evaluate the need for a project in conjunction with whether it duplicates resources, that is a way to address the needs, emergency needs in West St. Lucie County. How and to what extent that $6 million expenditure could address the same needs that were purported or that were delineated in the application, I think is a fundamental question. If you look at their application, both the 6th application and the 7th application, the need for emergency services in West St. Lucie County was one of the biggest factors that Martin cited in support of both applications. As I indicated earlier in response to Judge Padovano, that need was determined not to be compelling enough in denying the 6th application. What is different about the need out there now? Well, the only thing that's different is you've got a $6 million off-site emergency department that can alleviate that need, and that has not been fully considered or evaluated in this case.
Well, the population figures changed too, didn't they? I mean,
Your Honor, I think what you'll find, if you look at the record closely, the 6th application had some population figures that were set forth. The 7th application indicated that there had been some increase in population projections. But between the time that the application was filed and the time we went to hearing, there actually had been a decrease. And Dr. Stan Smith from the University of Florida, who was one of the witnesses that talked about the population demographics, actually reduced the population projections that were in his 7th application. And the numbers that were in, that he actually testified to at hearing.
Are you talking now about one side of the evidence?
I think the evidence is clear that he, in his deposition and the evidence that was presented at the hearing, this was the witness that Martin Memorial presented to support the demographics. He reduced his projections so that the projections were very close, if not identical to, they weren't identical, but they're very close to what was in the 6th application. And the judge, the administrative law judge in the case below, did not analyze how that reduction in the population projections correlated to what was in the 6th application that was denied. Because the 6th...
Where do you think that the ALJ went wrong? I mean, you think the ALJ just said, well, you know, you've been here 6 times before. I'm sick of hearing from you. I'm just going to go ahead and give it to you just so I don't have to deal with this again? Or what's your view on how this happened?
Your Honor, I think there's a couple things. I think that, number one, the ALJ did not recognize, did not go back and consider the effect of the prior final orders. And one of our contentions goes to the doctrine of administrative finality, but more than administrative finality. What is the precedential value of 6 final orders denying an application in essentially the same
How can there ever
location.
be any precedential value in a proceeding that has as its very essence the need to determine the current need for something? I mean, this is not like revoking a teaching certificate. This is a question that is constantly changing.
Well, certainly there's dynamics in the healthcare market. There's no denying that. But I think one of the things that's important to recognize
And
is...
dynamics in the process.
Pardon?
And dynamics in the process.
Right. There are dynamics in the process as well. And I think one of the important things to recognize is that the agency, the way that the CON process is set up is that there's supposed to be a published need for a new facility, and then applicants have the opportunity to submit applications within a batching cycle process so that you can have comparative review of different proposals. None of the 7 applications that were submitted by Martin Memorial were submitted in response to a recognized need by the agency. Now, it gets a little bit confusing because there were some changes in the regulatory framework during the course of these proceedings. There used to be what was called a fixed need rule, where the agency would do an analysis of the healthcare needs and publish whether there was a need for a new hospital. The first 4 applications that were submitted by Martin Memorial were submitted at a time that there was a fixed need rule. That fixed need rule was repealed, and the last 3 applications were submitted without a fixed need rule. So in those instances, there's a requirement in the rules, 59C1008 3CE, or 3E, I think. It's cited in our briefs, Your Honor. But basically, it requires that in the absence of a recognized need by the agency, it's up to the applicant to submit a needs assessment methodology to justify its proposal. So the 5th, the 6th, and the 7th application that were submitted by Martin Memorial were submitted under that rule, which required them to come up with a needs assessment methodology. And one of the things I think is very interesting, if you sit down and you look at the applications that were submitted, and we included in our appendix excerpts from both the 6th application and the 7th application, the arguments in support of need are virtually identical in both the 6th and the 7th application. In fact, the section, if you look at the pages, I think it's behind tabs A4 and A5 in our appendix. There's page 2, I think, where you can see that the italics and the bolding in the arguments in support of need are identical in both the 6th and the 7th applications. So what we've got here is a situation where they had the same need methodology that was used in the 5th application, the 6th application, and found to be insufficient. And in the 7th application, they tried the same approach, and they won that time. So I would submit that, yeah, there are changes, but when you have the same need methodology that's been determined to not be sufficient in final orders by the agency, that is an important precedent that needs to be fully considered and distinguished before you can enter a different conclusion on the 7th application. This is not a situation where this is the first time that they submitted this approach.
So you would say that any time an agency enters an order that fails to distinguish the prior decisions of the agency, that it must be overturned?
No, sir. I'm not. I think, obviously every case has to be evaluated on its own merits. I think that what has to happen is there has to be a recognition that the final orders of the agency have precedential value. The regulated public relies upon the final orders for the announcement of the agency's policies and the agency's analysis of the various issues. So it's important. It's not just between the applicant and the agency. I'm sorry.
I just want to alert you that you're into your rebuttal time.
Oh, okay. I'm sorry. I'll save the rest of it for my rebuttal. Thank you very much.
Good morning. I am Paul Amundsen. I represent Martin Memorial, the applicant, and Ms. Cooper from the Agency for Healthcare Administration is also here, and I would reserve 2 minutes for Ms. Cooper, and there won't be rebuttal from me. So. The case law on administrative finality is pretty clear. There has to be, you cannot bar a decision based upon administrative res judicata or administrative finality if an application is supported by new facts, changed conditions, or additional submissions by the applicant.
Spell out the categories of differences between the 7th and the 6th applications.
Thank you, Judge. First, one of the differences between this case and the others, and it wasn't clear in the briefs of the appellant or here this morning, is this is the first case to be subjected to a formal Section 120-57 administrative hearings. None of the others were.
Oh, but that's not determinative, right? Under the Thompson case, the first application there was denied without a hearing of any kind.
Correct. The first 6 were. Yes, sir.
So that makes it just like the Supreme Court's Thompson v. DER case.
Yes, sir, except here, what we have now is 6,400 pages of record, 20 volumes of transcript, a new population study, a new traffic study.
And he says the new population study cuts against you.
No, Your Honor, it does not. The population study does show less population growth than was presented in the application due to changed economic conditions. But what the hearing officer found, what the ALJ found, was nevertheless fairly dramatic growth in the population. That's a finding of fact that she made based upon the evidence. Fairly dramatic growth. And moreover, in the previous applications, let's talk about impact on these appellants. In the previous applications, appellants send a letter to the agency saying this project is going to do bad things, it's going to hurt us, and so forth. And there was no hearing on those issues. At hearing, the judge found that the appellant's impact assertions are rejected as contrary to the weight of the evidence. That was what was found. That wasn't found in any other proceeding before. The population will support a new hospital and will offset any lost admissions that the appellants would experience. That wasn't found before. This is new information. Judge Clark, there were new conditions with this application. For the first time in this application, Martin Memorial conditioned the application to be at a specific site. That had not happened before. And the specific site was directly next to the Torrey Pines Institute for Molecular Research, which in the previous applications was an idea. In the instance of this application, Torrey Pines was there. They had research personnel in the area. They were building their building, and it was a reality. Gentleman from Torrey Pines testified.
And was there testimony that Torrey Pines was willing to, and looking forward to working with your hospital?
Yes, very much so. And that the selection of the site for their research facility was influenced by the idea that a hospital would be there. In addition to that, an increased commitment to Medicaid, to serving Medicaid patients. 11.1% of Martin Memorial's patient days in this hospital are going to be Medicaid or Medicaid HMO. That condition was not in any of the previous applications. There was new evidence concerning transportation and emergency medical services not considered before, and there was testimony by St. Lucie EMS concerning the St. Lucie River, limited numbers of ways to get across the St. Lucie River, bottlenecks during congested times, and so much so that the EMS folks had to double up their rescue trucks on the west side because the rescue trucks would be out of service too long, having to traverse back and forth. Another new factor, there has been talk around St. Lucie County for some time that a new east-west artery is going to be constructed and another bridge over the St. Lucie River will soon be there. At this hearing, and not before this hearing, city officials anticipate that's not going to happen until 2017. There's requirements of an environmental impact statement and so forth. So,
and what had been the earlier target date?
It was vague. No one knew.
And on the EMS aspect, there were people who testified that they would not take an ambulance to the freestanding emergency facility because they wanted to go somewhere where there was all the backup that a hospital could supply.
I do believe there was testimony like that, Judge, particularly if you have a heart attack, something like that. You're not going to go to the freestanding facility. It's not going to serve every kind of emergency, particularly an acute emergency. But, and let me be clear about the freestanding emergency department. That is an interim measure. Martin Memorial perceived that there was a need now, right now, for emergency services in that area. So that's what they did to fulfill that community need. When that community need, when the hospital is there, and it won't be for a while, but when the hospital is there, the freestanding ED will become some kind of other facility. The changes in this application are the subject of testimony, and I would direct your attention to the record, volume 39, which is transcript pages 273 through 276. That's our health planner's testimony, who outlines the changes. I have described them to you. There's competent, substantial evidence for that. The administrative law judge said there were sufficient changes. Another change is memorandum from Gary Cantrell, CEO of St. Lucie Hospital. This is in the record. It's in the application in volume 6, page 1092. Volume 6, page 1092. Mr. Cantrell's memorandum discusses what's called a bed crunch at St. Lucie and urging people to take steps to help alleviate that. It's this evidence of this bed crunch and long waits in emergency rooms while patients are waiting for a bed at St. Lucie. This was not in the previous application.
All right, so it's your position that whether or not these changes are material is a question that is itself within the expertise of the agency.
It is absolutely within the expertise of the agency, and that's what the law says, Judge Benton. It says that, and I'm reading from the Del Rey case from the 4th District Court of Appeal, similar issues, similar hospital applications, and it says here, the determination of whether a significant change in circumstances has occurred lies primarily within the discretion of the administrative agency. It goes on to say, Florida favors administrative hearings to develop and flesh out the differences between successive administrative applications. I would say, Judge, Your Honors, clearly this second application is supported by new facts. It's supported by changed conditions, and it is certainly supported by additional submissions. And what's in front of me there is just a tiny portion of the record in this case. And there is plenty, ample new evidence to approve the application.
What do you say in response to their contention that the ALJ wholly overlooked the plans to add 35 beds to an existing hospital?
Well, I don't think she totally overlooked it. She found that based upon the population and the population growth, that the existing providers the existing providers will still experience an increase, and it will offset, population growth will offset the lost admissions. Now, you don't need a certificate of need to add beds. Anybody can add beds to an existing hospital simply by notifying the agency. So it's not a situation where...
Did her order specifically acknowledge that she was aware of the additional 35 beds?
I don't see it in the order, no, Judge Clark. There was testimony about it. There were proposed findings about it. I can only assume that the judge took that into account when she found that all the providers will have sufficient admissions to meet their financial needs. The impact will not affect the quality of the existing providers. These are findings of fact. The providers are financially healthy, and the adverse impact will was not supported by credible evidence. There was evidence of capacity constraints at Lawnwood Hospital, where there were waits in crowded emergency rooms, persons waiting for beds for hours. Capacity constraints at St. Lucie, capacity constraints at Martin Memorial Hospital, my client. So this is not a case where administrative finality should control.
His fallback was that, as a precedential matter, the prior denials should dictate the result here.
Should the prior denials dictate the result here?
Yes, I believe that's the argument, that the fallback argument, that even if there's not administrative res judicata, that precedent dictates a different result than what obtained below.
Well, the evidence in the record demonstrates otherwise, Judge Benton. I mean, the capacity problems at existing hospitals, population growth is still going to be fairly dramatic, emergency medical services difficulties, no adverse impact on the existing providers, no new bridge coming anytime soon, new conditions to the application, more Medicaid. It is those previous denials, which never went to a hearing, did not have those elements.
All right, thank you.
Thank you.
May it please the Court, my name is Tracy Cooper and I represent the Agency for Healthcare Administration. The agency is here today basically to say that we followed the process. There were findings of fact made by the administrative law judge. We are required by law to accept those findings of fact. We entered our final order in accordance with the law, and you cannot, unfortunately, depending on your opinion on the hospital, overturn it unless our decision was arbitrary, capricious. So, you know, that's really the basic facts here. The agency does not support a rigid concept of administrative finality in this case. We support the concept that was laid out in the Thompson case and the Delray case, where changed circumstances, new information, these kinds of things that we believe were presented in this case can support granting a CON when it was not granted in the past.
Well, now, in Delray, the res judicata argument did not carry the day, right? That was just...
Right. They were basically laying out what it means in the administrative process. There is a certain amount of finality to the agency's decision, but you don't consider it final if there's something that's changed. You know, you have to have a way for the process to work, which this is a healthcare planning process. The agency has to be able to look at applications and distinguish where things have changed and where there are new differences, where there is new information, and to be able to react to that new information and to grant a CON when it's appropriate. And if there are no further questions, I will sit down.
All right, thank you, Ms. Cooper. Rebuttal?
Thank you, Your Honor. Just a couple quick points. First of all, with respect to the off-site emergency department, one of the issues that you raised, Your Honor, is perhaps some people might not want to go to be transported to an emergency department that was not affiliated with the hospital. I think one of the other aspects, though, is that building an off-site emergency department helps to decompress the existing emergency departments and makes the flow through any of those existing emergency departments better. So it does address the need issue, the need for a new hospital, and the extent to which an off-site ED could address those emergency needs was a changed circumstance that should have been considered, and it's a changed circumstance that I don't believe was given adequate shrift during the course of the administrative proceedings below. Secondly, with respect to the access issues, I think if you look at the State Agency Action Report, the SAR, which is behind Appendix A3 that we submitted, you will see that all of those access issues, the bridges, the traffic, the obstetrical needs, all of those were discussed in the 6th application.
Or no, but he says there's more information, more clarity and certainty about when that new bridge is actually going to be built.
Well, Your Honor, I'm not sure. First of all, I don't think that's in the judge's, the recommended order that the judge entered. I think she dealt with it anew. And I think that one of the issues here and one of the problems that we have is that the administrative law judge in this case said, oh, there's a couple of new changed circumstances. There's been the time has passed, and therefore the prior decisions are irrelevant. And she didn't consider the reasoning or the basis for the prior agency denials, which I believe is improper.
Was the 6th denial done in an informal hearing? There was not a 12057-1 hearing?
Correct, Your Honor. That's correct.
How can you argue that there wasn't a substantial change if you don't know if there was no evidence before? In other words, if you had 2 evidentiary hearings, you could look at the transcripts and say, this is the same facts you had before. How do you make the argument that there wasn't a substantial change when there was no evidentiary hearing before?
And Your Honor, see if my time has expired.
Go ahead.
Okay, thank you. I think it's important to recognize that in reviewing the CON applications that are submitted, the agency does a detailed analysis, and that's in the State Agency Action Report, which we have attached as the Appendix 3 to our brief. That State Agency Action Report sets forth the preliminary agency evaluation of the application. It includes an analysis of access issues, utilization issues, need issues, all of those sorts of things. That State Agency Action Report becomes final if it's not successfully challenged. So that is the final agency action. So there is a difference in a case where there has never been a prior application that was submitted, and you're just dealing with the first State Agency Action Report, preliminary agency action. You go to a de novo hearing, you start over, and you evaluate it. But once there's been a final order entered on the prior application, it has consequences. Final orders have consequences, and at that point, it becomes the agency precedent. It's not just a matter between the applicant and the agency. There's a regulated community out there that has the ability or has to have the ability to look at that agency, that precedent as establishing the agency policy and evaluating the need for a new hospital in this area. So we have a situation where the agency had issued 6 final orders that are precedent that have to be fully considered, and they weren't here.
Thank you.
Thank you, Your Honor.
Thank you. We will be in recess. We invite you all to join us next door in the Lawyers Lounge.